to Insured Success, a podcast brought to you by Reed Smith's insurance recovery lawyers from around the globe. In this podcast series, we explore trends, issues, and topics of interest affecting commercial policyholders. If you have any questions about the topics discussed in this podcast, please contact our speakers at insuredsuccess@reedsmith.com. We'll be happy to assist.
Welcome back to Insured Success. My name is Catherine Lewis. I'm a senior associate in our London office. I am joined today by my colleague Emma Shafton, who is a senior associate in our global regulatory enforcement group, who specialises in white-collar crime and investigations. Today, Emma is going to talk to us about the two new corporate criminal offences contained in the Economic Crime and Corporate Transparency Act 2023, which came into force in the UK at the end of 2023. And we are going to share our insights on what this means for policyholders operating in the UK, the potential impact on your directors and officers and other insurance cover, and some of the steps that policyholders can take to mitigate risks. Emma, could you give us an overview of this new legislation?
Sure. So the Act, ECTA, I'll refer to it as, came about as part of the UK government's response to Russia's invasion of Ukraine in February 2022. By this time, there was an increasing understanding that London had become a dumping ground, really, for dirty money by foreign elites, kleptocrats and other bad actors, and that the UK's economy was being abused. So the Act represents a complete overhaul of the UK government's framework for tackling economic crime. The Act itself covers a very broad range of issues, beyond the scope of this podcast, including companies' house reforms. But today we're going to focus on two significant changes to corporate criminal law. The first is the new senior managers offence, and the second is the new failure to prevent fraud offence. So let's deal with the first offence first. So that's the senior managers offence, and that's under section 196 of ECTA. This came into force very quietly on Boxing Day last year, actually, and a lot of corporates have been caught by surprise by it. And it's worth flagging at the outset that this is completely separate to the FCA's existing senior managers and certification regime. These are different things. It's perhaps unfortunate that the draftsman of ECTA decided to use the same language because the definitions, unhelpfully, do not correlate. So I just wanted to flag that at the beginning. We're dealing with a completely new corporate criminal offence here. What the offence means basically for corporates is that if a senior manager of the organisation acting within the actual or apparent scope of their authority commits a relevant criminal offence, and those offences are economic crimes, so things like theft, bribery, fraud, false accounting, money laundering, and also certain tax offences. If that senior manager commits one of those specified offences, the corporate can be criminally liable now. What the repercussions of that would be is a very large fine, essentially. Now, this offence can apply to senior managers of a body corporate or partnership, and there's no size criteria or threshold. So that means that all organisations of any size could be liable so long as the jurisdictional requirements are met. This is a UK Act, and we'll come on to that later.
Interesting. This seems like a really big shift from the previous regime. Is that right?
It is. So the new senior managers offence is one of the biggest changes really in corporate criminal liability in over 100 years. So under previous law, which was Victorian law, corporates could only be prosecuted and criminally liable for the offences of its employees if it could be shown that that individual was acting as the directing mind or will of the corporate. And they had the necessary state of mind for the offence in question. So with a lot of the economic crimes, usually that involves dishonesty. So historically, this made it very challenging for authorities to prosecute corporates successfully because there's just a very small group of people who would meet that criteria of directing mind and will. And this is particularly so in large corporates with complex management systems. It became very difficult to identify whether an individual belonged to that group. So that was the sort of historic position. This new offence essentially makes it much easier for corporates to become criminally liable for the actions of its senior managers now.
So, who are these new senior managers that have been identified?
So this we foresee is going to be one of the issues with this legislation and for corporates in actually identifying who their senior managers are. And it's not entirely clear from the legislation. There's no guidance. The government are not required to publish guidance for this offence about this point. So the Act defines a senior manager as an individual who has a significant role in the decision making of the whole or a substantial part of the corporate, and someone who is involved in the actual management of the whole or part of the corporate. So it's somebody who's making decisions, really, somebody who is making decisions at a high level. Apart from directors, who are perhaps a sort of obvious class of people who would fall within this definition, other roles could include a regional manager, for example. But, as I've already said, it's not clearly defined who senior managers are. And it may be difficult in practice for corporates to identify who their senior managers are, because depending on the sector and the business, this may be a fluid category of individuals. We also foresee that one of the biggest challenges for prosecutors is going to be proving apparent authority. So actual authority, perhaps you might look at a job's description or somebody's responsibilities to determine what is within someone's actual authority. But what does apparent authority mean? It sort of implies that that person doesn't have authority to do the act in question. So we think there's going to be substantial debate on this topic, and it'll be very interesting to see. The SFO have indicated, the Serious Fraud Office, that they may publish some guidance about how this new offence will be enforced. So it will be very interesting to see in due course what they say about this. So that sort of is broadly the position on the definition of senior managers.
That's really helpful, thank you. And so is this senior manager offence limited to individuals within the UK?
So the definition of a body corporate or partnership in the Act includes those incorporated outside of the UK. So it's not limited to the UK. And what this means is that a non-UK company could be liable under this Act where an offence is committed by a UK national senior manager, for example, or by a foreign national senior manager when the offence is committed in the UK. So there is certainly a degree of extraterritoriality.
Really interesting. So it seems to me that policyholders will need to be carefully considering their directors and officers insurance as well as their liability policy wording to take into account these pretty serious and significant changes. Directors and officers, or a D&O policy, is one that a policyholder would typically look to respond if it's faced with an investigation or a potential investigation by a regulator or an authority in respect of the conduct of its senior management. And clearly an important point for policyholders is to, as you said, Emma, consider who their senior managers are and to ensure that those individuals are falling within any applicable policy definitions of individual insureds or insured persons. Are we expecting to see a significant number of investigations or prosecutions or penalties being levied as a result of this legislation?
Yes, we think so. So on paper, the offence is astonishingly wide. The group of individuals whose conduct can lead to the prosecution of their company for their actions, their criminal actions, it's really expanded. The pool of people is much bigger now. And therefore, the new offence significantly increases the risk of criminal liability for corporates. Well, of course, these offences are only as good as the enforcement agencies who might use them. So this offence is only going to be a game changer and is only going to see more prosecutions and so on if the agencies actually use them. So at the moment, we understand that the Serious Fraud Office are quite excited about this new legislation. Yesterday, I heard a senior person from the Serious Fraud Office describe it as a game changer, this offence, and said, where appropriate, obviously they will use this offence where they can. They've had a very bad track record of securing convictions against individuals in relation to corporate settlements and have lobbied very hard to change the law in this area. So, we certainly would expect to see them using this relatively soon in an appropriate case. And as I highlighted earlier, they've hinted that they are going to publish some corporate guidance in relation to this. So we await that with interest. There's definitely a sense, though, that the office is buoyed by this new offence. It's got a new director in place and are doing things differently, it seems. So we can expect the SFO certainly to be looking at this offence very closely. And then from an FCA perspective, they've recently published their 24-25 business plan. And commitment number 1 is reducing and preventing financial crime. So we would expect, the FCA to be looking very closely at this new tool available to them as well. Another point to highlight in relation to, whether this is going to see a significant number of or an increase in prosecutions and investigations, is that there is no defence. There's no defence of having reasonable procedures in place, which is very interesting. So, I think we can expect to see more investigations and prosecutions. The penalty is an unlimited fine for the corporate.
Wow, that's pretty significant for anyone doing business that touches the UK. So what can companies and businesses do to mitigate and reduce their risk? What steps should they be taking now?
Policyholders should identify their senior managers as the first port of call. And we've already explained that this may be challenging to do in practice, but that's the first point. And once you've identified that group of individuals, you need to consider the risks, really, that those individuals might do something that results in criminal liability for the corporate. So introducing comprehensive training relating to economic crime, money laundering for senior managers is going to be key. And I've referred to money laundering, and that's because it's very important to note that in addition to bribery, fraud, theft, and so on, there are some money laundering offences that are caught under this Act, in particular in relation to the AML mandatory reporting regime, suspicious activity reports. It's a criminal offence under the Proceeds of Crime Act when a relevant person in the regulated sector fails to notify the authorities about a suspicion of money laundering. And under this Act now, if that substantive offence could be made out, the corporate could also be liable, which wasn't the position before. So very significant changes here.
Yeah, absolutely. So moving on a little bit then, can you tell us about the new failure to prevent fraud offence?
Yes, sure. This is under Section 199 of ECTA. It follows the failure to prevent model that our listeners are probably quite familiar with now. So Section 7 of the Bribery Act was the first offence of this nature, and subsequently we've had failure to prevent tax evasion. The key difference, though, in relation to this new offence and the Bribery Act, however, is that it only applies to large organisations. Section 7 of the Bribery Act applies to all organisations, irregardless of size. So it's a smaller pool of corporates who will be affected by this, but the definition of large organisations for the purposes of this new offence is the organisation must have a turnover of more than £36 million, a balance sheet total of on aggregate more than £18 million in assets, or more than 250 employees, and it has to meet 2 of those criteria.
Thanks. And so how does the offence work?
So if you're a relevant body, so as defined, meeting 2 of those 3 criteria, that relevant body will be criminally liable when an associate of it commits a specified fraud offence. So there are 4 requirements of the offence. The first is there must be a specified fraud offence, and those are all listed, but it will be offences under the Fraud Act, false accounting, fraudulent trading. The second requirement is the offence is committed by an associated person to that corporate. So associated person is a term we're very familiar with from the Bribery Act, but it's an employee of a subsidiary, agent. Those are the sorts of people who are associated persons. It's apparent that the SFO is taking quite an expansive view of who falls within to associated persons, and recently indicated that it's looking at whether social media companies could be liable for failing to prevent investment fraud perpetrated on their platforms, for example. So that just gives you an idea of how expansively they are looking at it. The third requirement is that the offence is intended to be for the benefit of the organisation. The fraud doesn't have to be successful, doesn't have to 100% be for the benefit of the organisation, but it's important to note that if a corporate is the victim of an employee or associated person's fraud, they will not be liable under this offence. So that's an important carve out. And then the last requirement, the fourth requirement, is that no reasonable fraud prevention procedures are in place. If they are, it's a defence. The offence itself is actually not enforced yet, and that is because there is a requirement for the government, the Home Office in this case, to publish guidance, and that has not been finalised yet. There's draft guidance in circulation, and the final guidance is said to be expected imminently. The offence is meant to come into force 6 months after the final guidance has been issued. So it could be this year. We're waiting to see. In our view, though, that 6 month period isn't enough time for corporates to get ready.
Yeah, I agree. That seems like a pretty short amount of time to get ready for some fairly significant potential offences there. And I asked this question regarding the senior manager offence, but does this offence apply just to UK companies?
So there's also scope for extraterritoriality in relation to this offence. It depends really on where the specific underlying fraud offences take place. So a non-UK organisation could be caught by this offence where, say, an employee or agent commits fraud under UK law or targeting UK victims. So the key thing is where the fraud is taking place, not necessarily where the person is who's committing it.
Right, that makes sense. Are we expecting then to see a significant number of investigations and prosecutions once this element of the legislation comes into force?
Given the offence only applies to very large companies, we're not expecting as many prosecutions or a significant uptick as we are with the senior manager offence. But we are definitely expecting prosecuting authorities will look to use this new tool where they can. And it is possible to see joint charging because the way the legislation for the senior manager's offence is drafted, it's not the case that a senior manager has to be taken to a court, convicted, and only then once that conviction is confirmed, the prosecutor could then go on to prosecute the corporate. There's no requirement for that. So what we might see is joint charging of senior managers and corporates for the failure to prevent offence at the same time. As with the senior manager's offence, the penalty is an unlimited fine again. So it's essential that large companies are prepared for this legislation.
Yeah, fully agree with that. Let's go on to about what steps they can do to prepare. We talked about it a little bit earlier about the senior managers events, but what steps should policyholders be taking here?
The critical thing to do is risk assess, so specifically focused on fraud risk and the risk of other economic crime. And if a corporate has already undertaken a fraud risk assessment, that should be reviewed to make sure that it remains fit for purpose. As part of that risk assessment, you should be assessing your geographies, sectors, clients, and suppliers. So the second thing is, once you've done that risk assessment, ensure that you have proportionate policies and procedures in place to cover those risks. Identify who your most at-risk employees, subsidiaries, and associated persons are as part of that risk assessment. Consider introducing comprehensive training for your employees, subsidiaries, and associated persons in relation to financial crime risks. And monitor and incentivise compliance. Those are the key things that policyholders can be doing to prepare for this legislation.
This all sounds really critical for policyholders, and I expect that these are the sort of questions that insurers will be asking policyholders when it comes to renewing insurance policies. I certainly think we can expect questions about the identification of senior managers, as well as copies of risk assessments and reporting procedures, so any potential concerns are raised and addressed appropriately within the organisation.
Yeah, I totally agree. Are there any other final points from an insurance perspective that you think policyholders should be aware of when considering the impact of the two new offences?
There are, Emma, and I've been thinking a lot about all the really helpful analysis and explanation you've done of these pretty significant offences. And some of the key considerations I think that policyholders should have in mind entering into a renewal process since the introduction of the legislation and the two offences are: is there sufficient investigatory costs cover? So will the policy respond to an investigation being instigated by any of the authorities? And what is the trigger for any investigation or pre-investigation costs? So at what point does the policy step in and help a policyholder cover any of its legal costs or investigation costs in looking into the facts and events that the authorities are also looking at? And is there an extension for any specific pre-investigation or mitigation costs? It's also worth bearing in mind what the notification requirements are under the policy in the event that there is an issue down the line. When faced with an investigation or a request for information from an authority, that often requires a really quick response from the business, and the priority obviously will be engaging with the authorities, and insurance may not always be front and centre of everyone's mind. In that context, it's incredibly important that any notification requirements are not unduly onerous. So making sure that the policy allows for plenty of days for a notification to be made, and avoiding any conditions precedent to cover in case notification isn't made as promptly as everyone would like. When it comes to D&O policies, as well as having side A and side B cover protecting individuals, as corporate entities as well as natural persons can be liable under these offences, I think businesses should be considering whether they want any side C cover as well, and having a discussion with their broker about the benefits of having sort of this additional D&O cover. And a basic point, but nevertheless important one, checking an overall limit of indemnity, making sure that the limits of liability continue to provide adequate protection for the business, particularly in light of what, Emma, you've been saying about expecting an increase in investigations as a result of the senior manager's offence in particular. In my experience, when there's an investigation or inquiries are being made by a regulator or other authority, clients, customers, investors all tend to get pretty nervous. If things lead to a prosecution or a threat of prosecution, a policyholder might also start to see some civil claims coming from allegedly injured parties trying to seek compensation. So whether that's investors and shareholders or customers and clients. I think in those circumstances, policyholders should also ensure that any civil liability policies provide the right level of cover for their businesses. So that's it from Emma and I today. Emma, thank you for sharing all your insights on this important new legislation and your tips for mitigating and managing some of the risks. Don't forget to tune in to our next episode.
Yeah, thanks for having me, Catherine. It was great to chat about these new offences. And yeah, please do, everyone, feel free to reach out if you have any queries about them.
Insured Success is a Reed Smith production. Our producer is Alec McCardle. This podcast is available on Spotify, Apple Podcasts, Google Podcasts, Podbean, and reedsmith.com. To learn more about Reed Smith's Insurance Recovery Group, please contact Insured Success at reedsmith.com.
This podcast is provided for educational purposes. It does not constitute legal advice and is not intended to establish an attorney-client relationship, nor is it intended to suggest or establish standards of care applicable to particular lawyers in any given situation. Prior results do not guarantee a similar outcome. Any views, opinions, or comments made by any external guest speaker are not to be attributed to Reed Smith LLP or its individual lawyers. All rights reserved.